Good morning, philosophers. Today's lecture is the second in a series of two lectures on human freedom and its regulation by the state. Our discussion today will center around a case study, the controversial practice of commercial surrogacy, and the question whether it ought to be legally permissible or not. This is a fascinating topic in its own right. It raises deep questions about the proper scope of the market and possible moral limits on commercial exchange. At the same time, the article we will be discussing today, Elizabeth Anderson's classic paper, Is Women's Labor a Commodity?, also represents a very interesting counterpoint to the classical liberal position on human freedom and its justifiable restriction that we encountered in our last lecture on John Stuart Mill's On Liberty. Let us begin with some definitions. What is commercial surrogacy? Following Elizabeth Anderson, we will say that a commercial surrogate mother is anyone who is paid money to bear a child for other people and terminate her parental rights so that the others may raise the child as exclusively their own. Commercial surrogacy, so defined, is contrasted with so-called altruistic surrogacy, which is not financially compensated, for instance, because the surrogate is a family member or a friend. A second important distinction is between so-called traditional or genetic surrogacy on the one hand and so-called gestational surrogacy on the other. Let me explain. In traditional surrogacy arrangements, the surrogate mother is also the genetic mother of the child. She typically becomes pregnant by being artificially inseminated with the sperm of the intended father. However, with the development of in vitro fertilization in the 1980s, gestational surrogacy became possible, where the surrogate is not genetically related to the child she bears. Here, typically, a fertilized egg and sperm of the intended parents are implanted in the womb of the surrogate. Now, people resort to commercial surrogacy for a variety of reasons. They may seek a surrogacy arrangement when pregnancy is medically impossible, or when pregnancy risks are too dangerous for the intended mother, or when a single man or a male couple wish to have a child. Commercial surrogates likewise report a variety of motivations. The most commonly reported motivation given by gestational surrogates is, in fact, an altruistic desire to help a childless couple have a child. Other commonly given reasons include financial compensation, of course, but also enjoying the experience of pregnancy. Now, to get a better feel for what we're talking about concretely, let's look at some actual ads placed by would-be surrogate mothers on Surrogate Mothers Online, LLC. I'll highlight parts of these ads for you, but please feel free to pause the video and take in all the details, which are fascinating. All right, so here's the first one. I have finished having my own babies and would like to help a same-sex couple have a baby. I appreciate the struggles of the gay community and feel a gay couple will make wonderful parents. I will work with a couple in any state or international. I'm easy to get along with and willing to let the intended parents have whatever involvement they wish during the pregnancy and whatever they wish me to have after the baby is born. About me, 39 years old, mother of 5 children, happily married to a supportive husband. Here's a second ad, just from November of last year. I'm a 24-year-old mother of 1 located in New Jersey. I had a full-term, healthy pregnancy with my son and a healthy, normal delivery. No C-section. I love being a parent, and I would love to be able to give someone the opportunity to feel what I feel for my child. Children are such a bless, a love so unconditional, pure, and so innocent. I'm hoping to find intended parents close by, but if you are not close by, that is not an issue. Finally, here's a third ad that goes into a bit more detail, both regarding the modalities of the surrogacy agreement and the expected compensation. I'm a 43-year-old social justice graduate student living in the Twin Cities, Minnesota, wanting to be a genetic surrogate. My husband and I want to start our own alternative family. We have debt we feel we need to take care of before we can invite others to live with us. Working as an educator and my partner as a nonprofit worker, we're not rolling in the dough. We've spent the last few years getting our other ducks in a row and just need help with our last duck, finances, to get our family started. We will help you get your family started if you help get ours started. As we are both adoptees, we have no biological children and never had or will have a desire to have any. We know there are children out there that need homes and families, and we can be that. Nitty-gritty. Distance and travel is available for intended parents willing to pay. Contact during pregnancy is open to what IPs would like. Contact after is open. Twins negotiable. Reduction/abortion used if health of a gestational surrogate is in jeopardy. Willing to have birth in IP's home or birthing center. Compensation trade. You get a baby to call your own. I get $20,000 living allowance or pay credit card debts. That's negotiable. $200,000 in life insurance policy. Any and all expenses incurred due to pregnancy. So these ads, I hope, give you some more concrete idea of the phenomenon we're talking about, but also of the diversity of motivations with which would-be surrogate mothers enter into commercial surrogacy agreements. Now, the legality of surrogacy, both commercial and altruistic, varies widely around the world. As the graphic on my left shows, many countries simply do not have laws which deal specifically with surrogacy. Some countries ban all forms of surrogacy outright, whereas others prohibit commercial surrogacy but allow altruistic surrogacy. Others allow commercial surrogacy but only for domestic couples. In some countries, commercial surrogacy contracts are permitted and legally enforceable, whereas in other countries, while commercial surrogacy is not considered illegal, commercial surrogacy contracts are not considered legally enforceable. So in the case of a custody dispute between the surrogate and the intended parents, the court would decide the case on the basis of the child's perceived best interests. Now, in the United States, surrogacy and its attendant legal issues fall under state jurisdiction, and the legal situation for surrogacy varies greatly from state to state. Some states, such as California, facilitate surrogacy and surrogacy contracts. Others simply refuse to enforce them, and some penalize commercial surrogacy. Surrogacy-friendly states tend to enforce both commercial and altruistic surrogacy contracts and facilitate straightforward ways for the intended parents to be recognized as the child's legal parents. As a general rule of thumb, only gestational surrogacy is supported, and traditional or genetic surrogacy finds little to no legal support. Now, as this bewildering diversity of legal regimes suggests, commercial surrogacy is far from an uncontroversial practice. To many critics of commercial surrogacy, it raises deep questions regarding the proper scope of the market and the regulation of voluntary human behavior. We will delve into these criticisms of commercial surrogacy in a moment. But let's first very briefly state the case for the other side. Because, at least at first blush, it may appear puzzling why commercial surrogacy is controversial at all. It seems to be an exchange in which all participants benefit. The intended parents fulfill the fundamental human desire to become parents, and the surrogate receives agreed-upon financial compensation for her labor, which in itself is understood by many surrogates to be deeply meaningful work. So what reasons, we might wonder, could there possibly be to block a voluntary exchange from which both parties appear to benefit, at least all things considered? And there's a second puzzle. As we will see, many critics of commercial surrogacy believe that markets in women's reproductive labor, as exemplified by commercial surrogacy, are more problematic than other currently accepted labor markets. The Stanford political philosopher Deborah Satz calls this the asymmetry thesis, because its proponents believe that there ought to be an asymmetry between our treatment of markets in reproductive labor and our treatments of markets in other forms of labor. But what grounds do we have for accepting this asymmetry thesis? If it's morally okay to enter into contracts to perform other kinds of work, why would this not be so for commercial surrogacy contracts as well? What, if anything, makes women's reproductive labor a special case? In seeking to answer these questions, we will look at Elizabeth Anderson's classic article, Is Women's Labor a Commodity? A few words about Elizabeth Anderson. So Elizabeth Anderson, born 1959, is an American moral, political, and social philosopher currently teaching at the University of Michigan at Ann Arbor. She's published a number of important books: Values in Ethics and Economics, which came out in 1993, The Imperative of Integration, which came out in 2013, and Private Government, How Employers Rule Our Lives and Why We Don't Talk About It, based on the Tanner Lectures in Human Values that she gave here at Princeton University. Elizabeth Anderson's most cited and celebrated article, I think, is a paper entitled What is the Point of Equality?, published in the journal Ethics in 1999. This article is a polemical broadside against a school of thought in distributive justice known as luck egalitarianism, which we'll talk a little bit about next week. Instead, Anderson advocates for a more relational understanding of equality founded upon democratic principles. All right, so much about today's heroine, Elizabeth Anderson. So let's now turn to our first puzzle. What grounds might there be for regulating or even prohibiting a voluntary exchange such as commercial surrogacy, even one that promises to make both parties to the exchange better off, at least all things considered? Now, as we will see over the course of this lecture, Elizabeth Anderson makes a number of objections to commercial surrogacy, which can be roughly divided into three broad categories. First, objections based on harm to others. Second, so-called paternalistic objections based on harm or other disadvantage to the surrogate. And thirdly, so-called moralistic objections, which focus on the purportedly unethical character of commercial surrogacy arrangements over and above their effects on people's well-being. So let's now look at these three categories of objection in turn. In our last lecture, we studied a Millian position on regulating others' freedom. We saw that for John Stuart Mill, the only legitimate basis for regulating others' behavior is the prevention of harm to others. Or, as Mill himself famously puts it, the sole end for which mankind are warranted, individually or collectively, in interfering with the liberty of action of any of their number is self-protection. That the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. He cannot rightfully be compelled to do or forbear, because it will be better for him to do so, because it will make him happier, because in the opinions of others to do so would be wise or even right." End quote. So let us ask, could the practice of commercial surrogacy be said to cause harm to others? Are there grounds for regulating or even prohibiting this practice under Mill's harm principle? Well, Anderson answers in the affirmative. She thinks that even if a commercial surrogate willingly enters into a surrogacy agreement, such an exchange may still be immoral and the appropriate subject of legal prohibition because of the harm that commercial surrogacy does to third parties. First of all, Anderson argues, there are harmful effects on the surrogate child itself. As Anderson writes, I quote, "By engaging in the transfer of children by sale, all of the parties to the surrogate contract express a set of attitudes towards children which undermine the norms of parental love. They all agree in treating the ties between a natural mother and her children as properly loosened by a monetary incentive. Would it be any wonder if a child born of a surrogacy agreement feared resale by parents who have such an attitude?" End quote. But secondly, more than that, Anderson thinks the other children of a surrogate mother may also be harmed by this practice. As she writes, "The unsold children of surrogate mothers are also harmed by commercial surrogacy. The children of some surrogate mothers have reported their fears that they may be sold like their half-brother or half-sister, and express a sense of loss at being deprived of a sibling. Furthermore, the widespread acceptance of commercial surrogacy would psychologically threaten all children, for it would change the way children are valued by people, from being loved by their parents and respected by others, to being sometimes used as objects of commercial profit-making." Finally, Anderson thinks commercial surrogacy also risks doing harm to women in the wider society by reinforcing harmful stereotypes of women as baby machines. So, what should we make of Anderson's harm-based arguments against commercial surrogacy? It has to be said that a number of Anderson's empirical claims about the harms of commercial surrogacy are quite widely contested. For instance, a systematic review of 55 studies examining the outcomes for surrogacy for surrogate mothers and resulting families showed that there were no major psychological differences in children up to the age of 10 years old that were born from surrogacy compared to those children born from other assisted reproductive technology or those children conceived naturally. What is more, even skeptics of commercial surrogacy concede that there has been a dearth of work on the effects of commercial surrogacy on the surrogate's other children, and on children in general. Likewise, the empirical evidence regarding the deleterious effects on other women in terms of reinforcing harmful gender stereotypes is equivocal at best. So that's the first set of rejoinders to Anderson's first set of worries. Second, I think, there's the genuinely philosophical question whether a child born as a result of commercial surrogacy could really be said to be harmed by such an agreement, all things considered, given that in the absence of such an agreement, they would not have been conceived in the first place. So, even if we grant that the child may suffer certain psychological hardships as a result of being conceived in this way, what exactly is the alternative supposed to be for that child? To harm someone, many philosophers think, is to make them worse off than they otherwise would have been. But in the absence of a commercial surrogacy arrangement, this particular child would not have been at all, instead of existing with a life that, despite its hardships, is in all likelihood worth living for this child. So we will return to such philosophical puzzles surrounding the question whether there can be harms and benefits in procreation in the final weeks of this semester. Thirdly, even if it could be shown that a practice of commercial surrogacy does involve harms to third parties, do we think that these harms are serious enough to justify banning the practice, given the very significant benefits it also has to intended parents and to the surrogates themselves? Let's remember that under Mill's harm principle, harm to others is a necessary condition but not a sufficient condition for regulating others' freedom. So, in sum, I think, if harm to others were Anderson's primary argument for outlawing commercial surrogacy, her argument might seem on somewhat shaky ground. But of course, the claim that commercial surrogacy is harmful to third parties is by no means Anderson's only objection to this practice. A second group of objections to commercial surrogacy that Anderson marshals are broadly paternalistic in nature, since they focus on protecting the surrogate mother herself from harms or injustices to her. Recall from our last lecture our working definition of paternalism. We said, a policy is paternalistic if and only if it places constraints on the liberty of persons for the purpose of protecting and promoting their own good. The term paternalism is derived from the Latin pater, which means father. Now, this etymology is also closely connected to one of the most common criticisms of paternalism. It might strike us as arrogant and demeaning for others to intervene and correct my choices against my will on the ground that they know my own good better than I know it myself. Paternalism, in other words, seems to treat adults like children, depriving rational agents of the right to choose for themselves. In addition, besides these symbolic objections to paternalism, we saw that John Stuart Mill also objects to paternalism on instrumental grounds. Mill thinks that because an agent is a more reliable judge of his own good, at least typically, even well-intentioned others will typically promote my good less well than I would myself. Anderson, in her paper, however, gives us a number of reasons for thinking that this instrumental argument against paternalism might not apply so well to the case of commercial surrogacy. For one thing, it is very difficult to make a truly informed decision about becoming a commercial surrogate. For many women, pregnancy is what the philosopher Laurie Paul calls a transformative experience. For someone who hasn't yet experienced pregnancy and childbirth, it is simply quite hard to know what it will be like, and hence to make an informed decision concerning these matters. A fortiori, Anderson thinks, a would-be surrogate mother is not in a good position to know to what extent she will bond with her child over the course of her pregnancy, whether she will perhaps have a change of heart and want to keep the child, whether she will experience postpartum depression and other psychological complications, and so on. But in the absence of such crucial information, the argument goes, there may be less reason than usual to view the mother's consent to commercial surrogacy agreement as morally transformative, and perhaps more reason to try and shield her from the potentially disastrous consequences of failing to correctly predict her emotional reaction to becoming a mother. Now, while this problem of missing information and unstable preferences is undoubtedly real, it's not clear to me that by itself it would justify a ban of commercial surrogacy. Could these problems not be solved, or at least ameliorated, by better regulating the practice of commercial surrogacy? The American Society for Reproductive Medicine, for example, recommends that a gestational carrier preferably be between the ages of 21 and 45 and have had one full-term, uncomplicated pregnancy where she successfully had at least one child. So, if legal regulation required surrogacy agencies to screen potential surrogates according to these criteria, to include only women who have already had a pregnancy and who therefore have some first-hand experience of mother-child bonding processes, might the worry about later preference reversal and regret not be ameliorated to quite a significant degree? A second, quite different paternalistic worry is that the economic situation and motivational structure of many commercial surrogates leaves them vulnerable to serious exploitation. Now, To say that A wrongfully exploits B is roughly to say that A makes use of B's weak bargaining position or other vulnerabilities to take unfair advantage of B. For example, if a large multinational corporation leverages the high rates of unemployment and poverty in a developing country to make its employees work long hours for very low pay in unsafe sweatshop conditions, this may be an instance of wrongful exploitation. Given the lack of good alternatives, working for the corporation may well make the workers better off, all things considered, than not working for the corporation. But intuitively, the company is still treating its workers unjustly. It is morally indecent, the thought goes, to take advantage of another person's lack of bargaining power to pay them a relative pittance if the corporation could afford to pay them a decent wage instead. And given that commercial surrogates are often poorer women with few attractive alternative means of making money, and increasingly commercial surrogates live in the global south, one worry is that commercial surrogates are vulnerable to just this kind of exploitation from lack of attractive economic alternatives. However, Anderson also has a second, even more interesting worry about exploitation that I think is worth highlighting. So she thinks a commercial surrogate might also be vulnerable to exploitation, not just because of her weak bargaining position. Rather, what makes her particularly vulnerable to being exploited is that many commercial surrogates don't conceive of the surrogacy transaction as a bargaining situation in the first place. Many of the women who agree to sell their reproductive labor have altruistic motivations, at least in part. As Anderson writes, I quote, "A kind of exploitation occurs when one party to a transaction is oriented toward the exchange of gift values, while the other party operates in accordance with the norms of the market exchange of commodities. Gift values, which include love, gratitude, and appreciation of others, cannot be bought or obtained through piecemeal calculations of individual advantage. Their exchange requires a repudiation of a self-interested attitude, a willingness to give gifts to others without demanding some specific equivalent good in return each time one gives. The surrogate mother often operates according to the norms of gift relationships. The surrogate agency, on the other hand, follows market norms. Its job is to get the best deal for its clients and itself, while leaving the surrogate mother to look after her own interests as best as she can. So, this situation, writes Anderson, puts the surrogate agencies in a position to manipulate the surrogate mother's emotions to gain favorable terms for themselves. For example, agencies emphasize to prospective surrogate mothers the importance of the motives of generosity and love. When applicants question some of the terms of the contract, the broker sometimes intimidates them by questioning their character and morality. If they were really generous and loving, they would not be so solicitous about their own interests." End quote. So I think that Anderson is doubtless putting her finger on a real problem when she points out the problems that can emerge when a gift logic meets the logic of the marketplace. Another notorious example is the non-profit sector. It's a common criticism of charities and other nonprofits that they frequently take advantage of the idealism and sense of mission of their employees to pay them scandalously low wages. It sure seems gauche to bring up something as lowly as money and health insurance when you're busy saving the world, right? Similar dynamics, I think, are at work in academia as well, in the treatment of adjuncts and other precarious faculty. In a sense, then, Anderson is setting up a kind of dilemma. Either the surrogate is primarily motivated by money, but then she has the wrong attitude towards her child and her labor, as we'll go on to discuss momentarily. The child she gestates and her reproductive labor are treated as mere commodities. We'll explain that term in just a second. Or, second horn of the dilemma, she approaches surrogacy through an altruistic gift logic. But in that case, she's vulnerable to exploitation. So here's a little thinking exercise for you in the run-up to next week's town hall. Has Anderson convinced you that the worries about exploitation that accompany commercial surrogacy are sufficiently severe that they justify a ban of the practice? Or might they be solved, or at least mitigated, by a better regulation of the practice? For example, if economic disparities between developed and developing countries make surrogates in developing countries vulnerable to exploitation, well, then perhaps a partial remedy would be to prohibit international commercial surrogacy, as India in fact did in 2015, rather than prohibiting commercial surrogacy altogether. Likewise, to mitigate the problem that would-be surrogate mothers are exploitable due to their altruism, might it help to legally set industry-wide compensation rates for surrogate mothers, so that norms of commercial negotiation don't have to intrude on the individual transaction between surrogate and intended parents? I look forward to discussing these issues with you in our town hall next week. But for now, let's move on. So far, we've reviewed Anderson's objections to commercial surrogacy from harm to third parties and from paternalism. But neither of these is really what bothers Anderson the most about commercial surrogacy. Anderson's most fundamental problem with commercial surrogacy is not that the surrogate is exploited and paid too little. Rather, it is that she's being paid at all. In other words, the central objection to commercial surrogacy, according to Anderson, is that it is a fundamentally unethical practice because it improperly treats children and women's reproductive capacities as mere commodities. So let us unpack this third strand of criticism of commercial surrogacy step by step. According to Anderson, things traded in the market are valued in a certain way, namely for the use we get out of them, let's call that use value, or for what we can sell them for, let's call that exchange value. To say that something is properly regarded as a commodity for Anderson is to claim that the norms of the market are appropriate for regulating its production, exchange, and enjoyment. But not all goods, Anderson thinks, are appropriately valued as commodities. Some things, she thinks, are appropriately valued in a higher way. They are respected or appreciated or loved. As Anderson puts it, we value things not just more or less, but in qualitatively higher and lower ways. To love or respect someone is to value her in a higher way than one would if one merely used her. So, to treat a good in this second category as mere commodity is to fail to value it in an appropriate way. Anderson cites the example of chattel slavery, the buying and selling of human beings, as an extreme and particularly stark instance of this kind of misvaluation. According to Kant's famous formula, things have a price, but persons have dignity. So the fundamental problem with chattel slavery on this Kantian analysis is that it treats beings with dignity, beings worthy of respect, as if they were worthy merely of use. Now, of course, this is not what goes on in commercial surrogacy. Commercial surrogacy contracts do not enable fathers or prospective mothers to acquire full ownership rights over children. Even where there has been a financial payment for conceiving a child, the child cannot be treated as a mere commodity. As Deborah Satz points out in her book, Why Something Should Not Be for Sale, the father or prospective mother cannot, for example, simply destroy or abandon the child. He or she is bound by the same norms and laws that govern the behavior of any child's biological or adoptive parents. End quote. However, while comparing the treatment of the child in commercial surrogacy to the extreme practice of chattel slavery would miss its mark, Anderson does think that commercial surrogacy is relevantly like another practice that is widely viewed as a morally impermissible commodification, namely baby selling, or giving up children for adoption after birth in exchange for a financial fee. So what we might call her argument from baby selling runs as follows. First premise. Baby selling is a morally impermissible form of commodification and ought to be outlawed. Second premise. Commercial surrogacy is baby selling, or is at least in the morally relevant respects exactly like baby selling. Therefore, conclusion, commercial surrogacy is a morally impermissible form of commodification and ought to be outlawed. Now, in support of the first premise of this argument, Anderson argues that, quote, baby selling substitutes market norms for some of the norms of parental love. Most importantly, it requires us to understand parental rights no longer as trusts, but as things more like property rights. That is, rights of use and disposal over the things owned. For in this practice, the natural mother deliberately conceives a child with the intention of giving it up for material advantage. Her renunciation of parental responsibilities is not done for the child's sake, nor for the sake of fulfilling an interest she shares with the child, but typically for her own sake, and possibly if altruism is a motive for the intended parent's sake. She and the couple who pay her to give up her parental rights over her child thus treat her rights as a kind of property right. They thereby treat the child itself as a kind of commodity, which may be properly bought and sold. End quote. But in these respects, Anderson then goes on to suggest, commercial surrogacy is just like baby selling. It too involves agreeing to give up one's parental rights in a child in exchange for a monetary reward, where the decision to renounce one's parental responsibilities is taken not with a view to the child's best interests, but for financial gain. Hence, if baby selling is an inappropriate commodification of human beings, as most of us believe, so is commercial surrogacy. As Anderson writes, all of these substitutions of market norms for parental norms represent ways of treating children as commodities which are degrading to them. Degradation occurs when something is treated in accordance with a lower mode of valuation than is proper to it. Now, before we go on, I think it's time for another one of our thinking exercises. So do you think that Anderson's argument from baby selling is sound? And if not, which premise would you challenge and why? I'll give you a few minutes to think about it. All right, welcome back. So if we had to pinpoint the spot where the argument from baby selling is at its most vulnerable, where would that be? Well, I think that while some radical free market libertarians might want to challenge premise 1, I think that the most promising premise to challenge is definitely premise 2. Is commercial surrogacy really a form of baby selling, or at least in all morally relevant respects, indistinguishable from that practice? A common objection to that thought goes like this. No, commercial surrogacy differs in a morally crucial respect from baby selling. In commercial surrogacy, the payment is for the service provided, not for the product delivered. The surrogate is paid for the time and energy she spends gestating and bearing the child, and the risk she assumes in doing so, not for the child itself. In commercial surrogacy, especially of the gestational variant, you're paying to rent the surrogate's womb, so to speak, not to purchase a child. I think that Anderson would make two rejoinders to this objection. The first I've already alluded to. Anderson would probably reject the claim that all you are paying the surrogate for is her time and energy in gestating the child. More than that, she would say, you're also paying the surrogate to relinquish her claims to be considered for custody of the child. Without such a clause in the surrogacy contract, after all, which ensured that the child would be turned over to them upon delivery, the intended parents would feel far less comfortable about resorting to commercial surrogacy in the first place. But to the extent that the custody decision is taken not with the best interests of the child in mind, but simply in exchange for a financial payment, the surrogacy arrangement still treats the child as a tradable commodity. The second, and importantly, to the extent that in trying to rebut the argument from baby selling, her opponent claims that commercial surrogates are just paid to be a rented womb, Anderson would say that he plays right into the hands of her second worry about commodification. This is that commercial surrogacy commodifies and disvalues women's reproductive labor. So let's reconstruct this second argument of Anderson's step by step. Its first two premises are already familiar from our discussion of Anderson's previous argument. One, things traded in the market are valued for the use we get out of them or for what we can sell them for. Second premise, some other things are valued in a higher way. They are respected or appreciated or loved. Anderson now goes on to claim that 3, a woman's labor in bearing a child ought to be valued in a higher way and not for its exchange value or use value. However, 4, when a woman is paid to bear a child, her labor no longer is valued in the higher way. Rather, the woman and her labor are now valued only in the way commodities are valued in the marketplace. As Anderson writes, quote, when market norms are applied to the ways we treat and understand women's reproductive labor, women are reduced from subjects of respect and consideration to objects of use. If we are to retain the capacity to value children and women in ways consistent with a rich conception of human flourishing, we must resist the encroachment of the market upon the sphere of reproductive labor. This basic charge of Anderson's, that valuing women's reproductive labor appropriately is fundamentally at odds with reproductive services being bought and sold, is then further elaborated in her subsequent argument. She claims, 5, valuing women's labor according to the norms of the market disrespects and degrades surrogate mothers in one of 2 ways. Either, A, she is alienated from her labor and her child by repressing her emotions. The surrogate is required to engage in the emotional labor of attempting not to form a parent-child relationship with her offspring. Her labor is alienated because she must divert it from the end which the social practices of pregnancy rightly promote, an emotional bond with her child. Or, B, the surrogate mother is led to believe that the emotions she does feel are emotions that she shouldn't feel. As Anderson writes of a surrogate mother who has grown so attached to her child that she cannot bear to part with it, quote, what judgment do the norms of the market make of a mother who, out of love for her child, decides that she cannot relinquish it? They blame her for commercial irresponsibility and flighty emotions. Her transformation of moral and emotional perspective, which she experiences as real but painful growth, looks like a capricious and self-interested exercise of will from the standpoint of the market, which does not distinguish the deep commitments of love from arbitrary matters of taste, end quote. So, thus far, Anderson has been arguing for the claim that commercial surrogacy arrangements are morally wrong, in virtue of commodifying the surrogate's reproductive labor. The next premise in her argument then takes the step to claiming that they are not just morally wrong, but should be illegal. It goes like this. Inappropriate commodification, at least in serious cases, ought to be outlawed. Next premise, paid surrogacy is a serious case of inappropriate commodification. And from that we get the argument's conclusion. Paid surrogacy ought to be outlawed. So this second argument of Anderson's is very rich, and there are many points in the argument at which fruitful questions could be raised about it. I'll close this lecture by highlighting two of them for you in the hope that it will set up a good discussion for next week's town hall. So, first question. Notice that premise 4 of Anderson's argument assumes that there is a fundamental incompatibility between a woman selling her reproductive labor in the market and her reproductive labor being valued in a higher way. But must we accept this claim? It doesn't seem true in general that selling a good or service in a market and thereby attaching a price to it is incompatible with valuing it in a higher way. Here's one counterexample, courtesy of Deborah Satz. Quote, "I think that my teaching talents should be respected, but I don't object to being paid for teaching on such grounds. Giving my teaching a price does not diminish the other ways in which my teaching has value." End quote. Now, you won't be surprised to hear that as a professional teacher of philosophy, I'm very much in sympathy with this sentiment. The lesson of Satz's example, of course, is that just because someone is paid to provide a service does not mean that their service is necessarily valued merely as a commodity. Now, is there anything special about reproductive labor that makes valuing it appropriately uniquely incompatible with being paid for it? If so, what is it, do you think? Second question. As we've seen, Anderson rightly stresses that many women who engage in surrogate labor are actually motivated, at least to some extent, by an altruistic desire to help other people. Even though they're engaged in a commercial transaction, they don't view their counterparts in this exchange through a purely commercial lens, for example, purely as customers or sources of revenue. Rather, she thinks most surrogates are motivated by a humane and benevolent desire to help other people to recognize their dream of having children. And as we saw, that's also borne out by the classifieds that we looked at the beginning of the lecture. But by the same token, we might now wonder, do the other participants in the surrogacy exchange have to treat the surrogate's labor as just a commodity? If we're willing to grant, as surely seems psychologically plausible, that surrogate mothers often engage in commercial surrogacy with a mix of self-interested and altruistic motivations, then why assume, as Anderson seems to do, that the other parties to the surrogacy agreement, in particular the intended parents, are motivated solely in accord with market values? As Deborah Satz remarks, quote, "The couples that use contract pregnancy are not seeking to make a profit, but to have a child. Some of them might even be willing to maintain an extended family relationship with a surrogate after the child's birth." End quote. So, if this is so, and paying for the services of a commercial surrogate isn't, at least in principle, incompatible with having a humane regard for the surrogate's own well-being and emotions, then perhaps this saps some of the support for both of the claims in premise 5 of Anderson's argument. Moreover, insofar as there is, in practice, a tension between commercial surrogacy and valuing the surrogate's reproductive labor in a higher way, one might wonder whether this tension could not be lessened by reforms to the practice of commercial surrogacy, such as, for example, making surrogacy contracts not legally enforceable, or granting surrogate mothers a grace period in which they can change their minds about whether or not to forego their claims to custody of their biological child, as, after all, is already the case in many legal regimes governing adoption. So perhaps a wholesale ban on commercial surrogacy is too blunt and indiscriminate a solution to a problem that admits of a more satisfactory resolution. As I said, I look forward to taking these questions up with you in next week's town hall. Until then.